Cheers. Cheers.
To Michael.
Thank you.
You're delightful.
We're the three legal musketeers now.
We are.
Or mouseketeers.
Would you call this podcast club?
Yeah. It's podcast club.
Welcome to the club.
Yeah.
Welcome to the club.
There's 2 rules. We'll
Okay,
probably be a
okay.
third. Go ahead.
I just want to introduce the topic for tonight because
Okay.
before I started working at this firm, I was a rather notorious person in the men's rights community, and
They forgave you.
yeah, well, everybody should forgive me for that. But one of the things that was like a mantra in the men's rights community to protect themselves against false accusations, they said, always be recording. And I've made a point before that, you know, if you record surreptitiously, you could subject yourself to an extra charge. You know, it's not going to block you from being charged. You could actually end up with an extra charge.
Literally.
And literally. There's an inside joke. But so one of the things that we're going to the main thing we're going to talk about tonight is a case that just came out that was announced in the news that was from Ottawa, Ontario, where recording became a form of fraud. And this is very important that people need to understand. If you're going to record, that you have to make it clear that you're recording. And so let's talk about this case. You're the one who got the decision.
Right. But it's not just recording, it's recording with consent.
Right.
Big word.
Yeah, so this is going to be a somber, non-fun discussion because it's a case called Rockburn, Rockburn, and we'll flash the citation later when the podcast views. But Michael, why don't you set it up for us as to what were the charges that this gentleman was facing, and then ultimately just quickly what the decision was, and then I think we should dissect this case so people have a clear understanding of what the law is.
Well, in a nutshell, there were 2 complainants involved in this case, and both exes, I guess, at this point. He was essentially recording, having intercourse with them in various locations, whether it was in his truck, with another one it was in their bedroom. Both complainants weren't aware of this taking place. They knew there were cameras in the household, for example, but in their minds it was
Well, the one
with the landlord.
Yeah, because
in
there was
case
one
the
that was
landlord.
the bedroom, and there were cameras set up throughout the apartment because they had an issue with the landlord,
Right.
Entering the apartment without
Right.
permission. So she knew there were cameras, but she said she didn't know there was a camera in the bedroom.
Right.
And the other one was just in the truck.
In the truck. And in neither cases did they agree to this filming, videotaping taking
They said.
place. They said, right. And what he did ultimately was took these videos and uploaded them to Pornhub, I think it was, claiming he had run out of
With
cloud
very-
storage space.
With very
Descriptive titles.
unthought out titles.
to the videos.
He testified that he didn't think out the titles very well.
And at the end of the day, Joe will get more into the details, but at the end of the day, the judge basically found that, well, the fact that you did not let them know that this was happening essentially,
And obtain their consent.
well, I was going to say vitiated,
Well, and-
to use a big word, their consent.
And he did plead guilty to uploading the videos
Right.
without consent. So there's a number of different charges. He was originally
Right.
charged with, I think, 12?
Something like that, yeah.
Something like 12 charges, and then it got reduced down because he was pleading guilty to 2, and they withdrew 2 others as a result. So this is, originally when we first heard about this, one of the things that stood out is there's a specific crime of recording somebody and uploading videos or sharing videos even without putting them on Pornhub,
Right.
even if you just distribute the videos. That is a specific crime on its own.
Right.
And so where we got concerned about this case is that the recording of the videos, he was also charged with sexual assault, and there was no doubt from the videos that they were consenting to the sexual activity.
Right.
The question then became, does the recording of the sexual activity without them knowing it's being recorded, is that a form of fraud?
Right.
Okay, so let's break this down now so everybody understands, because it's really important. So so it's a case that's decided now. So there was, as you said, he recorded one of his partners in the bedroom of the home where they both lived, of the apartment. The other one was in a car. So he was charged with offenses under the voyeurism section of the Criminal Code, which is 162, sub 1. And that says that you are, it's a criminal offense to record anyone in a place where you can reasonably expect privacy.
That would be the bedroom, though, not the car so much.
Let's just get the offenses out, but yes. But there's different provisions. So he was charged with voyeurism because a surreptitious recording of somebody in a place where you'd reasonably expect that you could be naked and engaged in, let's say, sexual activity, that recording without the person's consent constitutes a criminal offense under voyeurism. And as you said, the bedroom obviously would be a place where you would expect to have privacy, to be naked. But there's other sections, and it could, if you're in the car, for example, and recording, you can argue under subsection C that it's an observation or recording for a sexual purpose. So although it may not be, a car is not a place where you would reasonably expect that type of level of privacy. I'm trying to just not be so much of a lawyer on this. You could argue in another section that there's a surreptitious recording done of sexual activity for a sexual purpose. But I just want to frame this because this isn't so much our main focus, but those were offenses that he was facing. In addition, taking the images then, the videos, and then sharing them without consent on social media or the internet or Pornhub is another criminal offense. So they faced that. He pled guilty to a number of the offenses. The main issue here was trying to argue that there was consent for recording. And then also the big question became, in this case, one that we were expecting to come down the pipe at some point, and this is why you raised what you said, was that the Crown then argued he was facing 2 counts of sexual assault in circumstances where you said very clearly, it was very clear on the evidence that these 2 complainants, or now we call them victims, had consent. It's very hard for that to come out of my mouth. Had consented to the sexual activity. So in fact, they consented. So the argument here was whether
that consent was valid.
Whether the consent was, we call it in law, vitiated. So whether it was valid is a good way of putting it, because they were not informed that he was making these surreptitious recordings. And then we'll get into this other analysis where it's like, whether does it vitiate consent, or is this no longer a consensual act? It's a bit complicated,
let's
but it's...
clarify what you look at in terms of consent. So consent is in the mind of the complainant. It's subjective in terms of whether they did or didn't.
Yeah, so just, again, break that down for one sec. So in sexual assault, a sexual assault is, a sexual act without consent. So consent is, like you said, in the mind of the complainant, but go ahead.
And, what's in the mind of the complainant, if they don't express what's in their mind, then you can get into honest mistaken belief, which is a whole other thing we're not going to get into right now.
Yeah,
but,
bless you.
but also, what we're looking at specifically in this particular vitiating of consent, like having the consent be not valid anymore, is what is the act that you're agreeing to and what constitutes fraud. So this is something that, do you want to try and break that down?
Well, yeah, and we've talked about this earlier today. What is the fraudulent aspect of the interaction that's taking place? For example, if you pretend to be a modeling scout and you're scoping out young girls and they think you're a real talent agent or modeling scout, is that then some sort of fraud that, and then they have sex with you, is that vitiated in any way or not? I think that's what you're getting at, right?
Well, there's a decision from a few years ago called Hutchinson,
right,
which then there's a new decision that came out this year, Kirkpatrick, that almost, they say it didn't reverse Hutchinson, but it kind of did. So Hutchinson was saying that when you consent to an act, you don't have the right to choose the qualities of that act or the circumstances or whatever. It's like, if you consent, you consent. But then there can be fraud, but what constitutes fraud? And this primarily had to do with the use of condoms.
Right.
And then then we had this new decision come out in Kirkpatrick that said that it overturned it because they said condom usage, because one of the problems with birth control is that women can say, I'm taking birth control, but they can be lying about it.
Right.
And so they didn't want to capture women who were lying about taking birth control in the decision that they put out in Hutchinson. Now they've reversed it and they've said that this is a qualitative aspect of the decision, but then they put something in there to try and make women immune from it.
Yeah, so I think we need to spend a little bit more time to explain to everybody the difference between those two cases. But you raised an important point. So this is where people may not quite understand. So agreement to sex is a voluntary agreement to engage in sexual activity, and the consent must be present at that time. And that's generally in the mind of the complainant, and it can be communicated either through words or through actions. Right. So in this case, what the Crown was arguing is that under the criminal code, that consent is no longer valid, or as they use the term in law, it's vitiated, because he obtained her consent without telling her an important factor, that is, I'm recording us. And so the fact that there was a surreptitious recording without consent, the argument from the Crown, ultimately accepted by the judge, was that constitutes one of those provisions under the code where you
deception.
Can invalidate it. It's a deception.
So they said that it was such an important factor that the sexual interaction was being recorded, that it constituted a deception because of a failure to inform.
Yeah, so that's correct. So it's a form of non-disclosure or dishonesty, which can lead to fraud. And then the other element is, it's important to know, there's a deprivation or risk of deprivation in the form of serious bodily harm, which results from this dishonesty. I just want to say this slowly, okay? Yeah. So in order to find a fraud...
Pause.
In order to find a fraud, to invalidate the consent, it has to be established by the Crown beyond a reasonable doubt that there's dishonesty, which can include non-disclosure of an important fact. So 1, non-disclosure of the surreptitious recording without consent. 2, can they establish deprivation or risk of deprivation of serious bodily harm, which includes psychological harm.
Yeah.
And that's the slippery slope we're on now. What constitutes psychological harm versus mental distress? Something's unpleasant versus psychological harm.
Yeah, and in this case, look, it's he uploaded it to Pornhub. It's kind of hard not to argue that that's going to cause the person psychological harm.
So here's another thing too. Like, we've had a number of decisions from the Supreme Court that are really dangerous in a lot of ways, but I can see why they ruled in the way they did, because some of these cases that go forward, they have slimy facts, and this is the case where I can see it's a provincial court, so it's not an authority, but this is a person who
the judge might beg to
uploaded
differ with that. But
uploaded things to Pornhub and called them things like, girl takes my seed or whatever. Like, the titles to the videos were really gross, and these are in the decisions. Like, and it played a big role in the way, the perception of. In his explanation for why he uploaded to Pornhub, well, they were really ridiculous in a way. He's saying, oh, well, my phone was running out of storage space, so I just thought I'll use Pornhub as storage space.
Yeah, it's not iCloud, is it?
Yeah, I know. It's not Google Drive. It's,
no.
So the explanations, you can see why they were rejected. So, but these cases, there are other people who can be caught up in these decisions, who are not in the same situation. But when a case like this with really kind of slimy facts goes forward, it ends up setting law for other people that get caught up in because one of the reasons I love the law is something's true. It's true across the board. Mm-hmm. But one of the things that's problematic about the law is that if a decision is made based on a case with slimy facts, then it affects other people who ultimately it can take a long time to say, our guy's not like that.
What's the old adage? Bad facts make...
Right. Bad cases and bad appeals.
Bad law.
Bad law, yeah.
And so what's really I think at the nub of this is that, why I sort of got very concerned about this was we in a previous episode was discussing the Johnny Depp case. And
sometimes recordings could be very helpful, but
yeah, and
sometimes they can
then
make
there
your
was
case
another
worse.
case where the police in the United States were being sued, and there was a deposition of a police officer, and she was saying, that I presumptively believe what a complainant says. There's nothing that I always operate that the accused is guilty. And then one of the questions by the lawyer in the United States was, what would prove you otherwise? Well, unless there's like a video recording of the actual act,
Right.
Nothing's going to displace my belief that this is anything other than a sex assault. So it just, I know people get frightened and they can try and do things for certain purposes, assuming they're not doing it for a sexual purpose or to upload to the Pornhub. Here's a case, like you said, where another person may have, for whatever reason, recordings in their room. Not a bedroom that they share with other people. So somebody comes over, and somehow that recording gets found out at some later point in time, not distributed, not shared, but it constitutes voyeurism. And then, based on these facts, can vitiate consent. Because what they said here, let me do this one other one. Recording is at the same risk of whether it was shared or not. So it's always there that once a person has a digital recording, it could be uploaded and shared. So even if it's not shared, it still constitutes the same psychological harm.
And that's the scary part.
Yeah, so I don't know. And I think what's important here, for as we discuss this, is just to talk a little bit about this Kirkpatrick and Hutchinson decision. And I'm going to refer to, if you want to jump in on this.
The slippery slope of what constitutes fraud. Because one of the things you're like, oh, well, if you tell somebody I'm going to university, I'm in university and I'm studying to be a doctor, and it turns out you're in university taking a lower course, what doesn't have the same amount of income to it, is that fraud? Because she's having sex with you thinking you're a doctor.
Yeah, it's a good point.
And that's one of the concerns. And then also there's a concern, like mentioned earlier, even in terms of important issues like birth control. Well, a guy says he's going to use a condom. What about a woman who says, I'm taking birth control pills, but turns out she's not?
Yeah.
And they don't want women to be caught up in this fraud.
So
I think, how do you mitigate that?
Well, I think even leaving that aside, I guess what you're addressing right now, because what I wanted to look at was, and it's not so important for people who are viewing this to title these two Supreme Court of Canada cases, but one of them was about, sex without a condom. And the Supreme Court had said that's part of the actual sexual act. The person agreed to the sexual act with a condom. Therefore, if the condom wasn't used, it's not a fraud.
That was Kirkpatrick.
I know. I don't know if they care so much about whether it's Kirkpatrick
Hutchinson,
or not.
they said it's not. It's not.
Right. So
included.
I'm just trying to explain the point that the Supreme Court of Canada said that the sexual act includes the condom. Therefore, it's a sex assault. In Hutchinson, it talked more about fraud. In other words, if somebody did something, let's say they sabotaged the condom to have had intercourse, hoping to impregnate the other person, that would constitute a fraud. And it seems that what happened in Kirkpatrick was that they expanded the definition of sexual activity. And that's what we spoke about in a previous podcast, and we said that could be quite dangerous. This case, the judge limited that case, Kirkpatrick, and said, well, I see this as a fraud situation. But then we come back to the question is it a fraud? Is this something that should lead to the vitiation, do you mind pouring? The vitiation of consent, such that the person's now convicted of voyeurism, sharing, and then sexual assault. And you can imagine in those circumstances, you're talking about a very significant jail sentence.
Mm-hmm.
And I'm not saying that, the person who's the victim of this doesn't have serious psychological harm, and it's something that's on the internet and very hard to get rid of, is not deserving of a high sentence. But I'm not trying to downplay one versus the other as far as the cases are concerned, but from a conceptual standpoint and from a criminal justice standpoint, is it necessary to convict of all these offenses? Or could you just simply the sharing and the surreptitious recording offense mete out a really big sentence on that one, as opposed to the vitiation of consent. Like the concept of dishonesty, which can include the non-disclosure of important facts and a deprivation or risk of deprivation in the form of serious bodily harm, which results from the dishonesty, was always to me something more narrow. Something more like, in the old days, we had of a transmitted disease, for example.
The HIV cases.
And those, it's different now because if the viral load is extremely low, you don't need to disclose that. Perfect, get it, I understand that. Back in the day, that might have been different when there wasn't the medication. But let's imagine there's some other disease or something else that the person has which is not treatable, only manageable by medication, and the person doesn't talk about it, so it's not an informed consent. I get that, because there's risk of bodily harm here. I think it's open to debate, and I'd be interested to hear, from our viewers by commenting or sending in emails as to, is this a situation where they have to find, where a court has to find, and our criminal law has to go in the direction of saying, the surreptitious recording in your bedroom of you and your partner without the partner's consent is of such a level of important fact that it amounts to this type of fraud.
There was comment in the most recent case, which, we should mention, was kind of following the Alberta Court of Appeal on a case called AE. We should talk about
that. Yeah.
Okay. But there's another point I want to make first, is that we have the internet now. And it's really important because you can be recorded in somebody's home, but also people go on the internet and they engage in live chats or whatever, which can be recorded by a person on their screen. People put themselves out there in all kinds of ways, and then it becomes scary. What is that person? Did they record it? And so this is one of the harms that they talked about, that they said it wasn't just the fact that this individual in this case uploaded the videos to Pornhub, the fact that they had the videos. And the reality is a lot of people go online nowadays, and this is so important to understand, that when you go online and you start engaging in these kinds of sexualized discussions, videos, enabled and so on, that anybody can record it. And the harm that they described, saying they weren't just impacted by it being uploaded, but they were impacted by knowing it was recorded.
Because there's always the chance they can be shared.
So this is something that I think parents need to really educate their children on. It's so important for them to understand that, you're getting, it's there and it's available, and this is something that didn't exist when we were born, right?
And it's there forever, pretty much. It's
And
hard to
you
get
never
it
know
off.
what somebody's going to do with it. And it's important for people to understand before they do it that, you engage in these kind of talks, you don't know who's recording what.
Well, it's true. I mean, you can record over Zoom, you can record over Skype, you can record over many of these.
Yeah.
And you don't even know what's happening.
All these other apps.
Yeah, you don't even know what's happening, right?
Right.
Yeah, you don't. But we're going to talk a little bit about this decision, and it is a provincial court, so it's a lower court decision in Ontario that
We can expect an appeal.
We're discussing. But it's based on an Alberta Court of Appeal decision from a case called AE, which again was very bad facts. And so the Alberta Court of Appeal was looking at this case that had a number of guys and then this one particular girl who was involved, and there was some filming that took place. And so one of the things that they said in the decision was that this recording, she did not know she was being recorded, and they thought that vitiated her consent. Then it went to, and I know you have a copy of it. It went to Supreme Court, and Supreme Court.
Boy, every episode we're getting more and more cases.
It's a staple. This is 3 pages. It's 3 pages.
Here, Michael, if you want to
And I love these 3 pages because this is something that it's a big issue. Can you record? Can you not record, or whatever?
No, I think this is the reason we all decided to do a podcast solely on this case, is because we consider this to be a serious issue, and how easy it is to record, and how some people may think defensively they should be recording, yeah, right. And more importantly, I think there's a valid discussion. There's a legitimate discussion about whether this should be a fraud. And I'm not trying to, again, impugn the harm that these complainants or victims feel. I'm just saying, is it a f***ing sex assault, or is it something else? And do we need to broaden this scope of dishonesty and fraud vitiating consent?
What constitutes fraud?
Why do we need to do that?
Especially when there's any number of other offenses that he had, right? Like, there were so many offenses.
You can give significant sentences,
right, for the other stuff.
The only time they get cautious is when they think women are going to get caught up in it. That's seriously, I'm going to tell you, it's the only time when they're talking about coercive control.
It's not about women.
They just don't want women to be caught up in coercive control.
Sidelined. We were in court today on a motion where we're actually bringing an application for expert evidence to be called that our male client is a victim of abuse by his wife, the complainant, or his ex-wife, thank God. In all the material that we filed with very detailed affidavit evidence, you made a good point. Neither the Crown or the Complainants Council even bothered to acknowledge
that was part of the defense.
That's part of the defense. They completely sidetracked it, ignored it, tried to make sure it couldn't get in anyway. Nobody wanted to acknowledge it. So you make a very good point. And by the way, we will come back to see if we're successful in this expert evidence, because I think it's going to be the first in Canada. But leaving that aside, you're right. The courts are concerned only upon where it could then harm women. Yeah. And that's like, not using birth control, but...
So the Supreme Court, this case of AE, in terms, we're talking about, this is referred to by the recent decision in Ottawa. They said, oh, well, the Court of Appeal in Alberta in AE said that that surreptitious recordings would vitiate consent, and I agree with them. But this went to Supreme Court of Canada, and they agreed with the Court of Appeal on other grounds. What they said about the recording, we note that the Court of Appeal of Alberta addressed...
Say it slowly so everybody gets it. 'Cause it's a good f***ing thing.
I know.
It's like...
We note that the Court of Appeal of Alberta addressed other issues in obiter. That means just a side comment. Including TCF's liability for sexual assault with a weapon, whether surreptitious recording constitutes fraud vitiating consent, and whether consent to sexual activity can be given in situations involving intentional bodily harm. In the circumstances, it's unnecessary for us to address these issues.
Yeah, like, seriously?
Explain for us, you've done a lot of appeal work.
Right.
Why sidestep it like that?
So
Look, that's what I do. I throw shit. Just kidding. Why would they sidestep it?
They're not ready to deal with it. There's not enough cases from across the entire country to consolidate into one leading decision. They're probably saying, we're not ready. We're not ready to dance yet.
But they just did Kirkpatrick, talking about fraud vitiating consent. Why? And they're seeing this as a live issue. Why would they just say, you know what, let's wait for somebody else to appeal it? Let's not... We know it's an issue. Nobody knows what to say about it.
Defend the Supreme Court, man.
But we know courts are terrified of addressing technology. So this is a new technology. They're terrified. What does this now mean?
And I guess...
But they have to decide at some point.
And they're saying, later, we got other stuff to do.
Let's let somebody else get wrongfully convicted, and then we'll deal with it later.
If it gets up to them.
Yeah.
Because not everybody can afford an appeal all the way to Supreme Court again.
Let's let people get convicted differently in different provinces, because nobody knows what to do about it.
Like, how many teenagers are going to get caught up in this?
It's not so uncommon, and then you have to have a build-up of a particular case with particular facts to then go to the Supreme Court of Canada.
But they literally say they know it's an issue, and they're but we're not going to decide. Right.
Yeah. So, but here's the takeaway, and I don't know how we're running, but here's an important takeaway.
Can you tell I'm angry?
She threw stuff, so she's a bit angry.
So, and I get this. Again, I'm not trying to be overly critical, because I get it. I understand the rationale and the argument, but it was written in the AE case that
Please remain.
Fraud needs to be interpreted in light of the values of equality, autonomy, liberty, privacy, and human dignity. It was decided that recording of intimate sexual activity is a significantly deceptive act, and so therefore needs to meet the test. And particularly in this case, relied upon this analysis or this rationale that the recording of sexual activity without the complainant's knowledge and consent meets the first part of this fraud test.
Slow down.
You're right, sorry.
Slow down, yeah.
Recording sexual activity without the complainant's knowledge and consent meets the first part of this fraud test because its non-disclosure is an important fact, which is a form of dishonesty that involves a violation of a person's dignity and privacy. Yes. But it leads to a conviction of sexual assault. And maybe I'm just wrong.
It's a separate charge. We already have a charge for that.
Yeah, I think this is a valuable debate, and it's like.
And that's the weird thing in the rock. What is it?
What do you need?
Rockford.
Rockburn.
Coming right up.
He was charged with a number of things. Only 2 of them were sexual assault. Rockburn, and so only 2 of them were sexual assault. All the other charges were related to the recording. He was already being charged and pleading guilty and being convicted of things related to those. So
Overkill.
It's overkill.
It was overkill. It was.
So let's just frame this for a moment, okay? So I get, the Crown may say that the punishment in question is not sufficient under the provision. So, just for example, for voyeurism, if the Crown proceeds by indictment, and that's up to them to decide. So if it's a more serious level of offending, they can proceed by indictment, and a sentence can be up to, but not exceeding 5 years in jail, which is a long period of time in jail. And what was the sharing provision? That also includes something similar up to about 5 years of jail. And I just want to see if I can get that. So
yeah, most of the charges were under 162.
Yeah, and then there's the sharing without consent. Here we go. So it's 162.1, publication of an intimate image without consent. And then again, you're looking at not more than 4 years by indictment. Okay? So conceptually, let's talk about this for a second. I'm just dropping shit everywhere.
Just throw it.
Let's just talk about this for a second, because I'm
in the mood for throwing
if this was a repeat customer, okay, who had other similar offenses, you would say, a maximum of 4 or 5 years might be just way too light. Forget it. No way. But even on a sex assault in these cases, what's that going to be worth? 2 years in jail? 3 years in jail, maybe less, because it wasn't forced sexual act. It was just vitiating it. So how you quantify that by way of a sentencing, I think is going to be an interesting thing to see what the sentence is going to be in this case and then what the higher courts say about it. But let's say it's 2 years. Let's say they add on top of it a year for the other charges. You may get a global sentence of 3 years. Anything higher than that, I think, would be reduced on appeal. Am I wrong?
No,
well,
you're right.
We're getting a little bit technical now, but I think the closing point is...
I think it's really important. I think this technical issue is actually important for us to have a dialogue about this. How much more do we need to label and criminalize an individual for a bad thing? I'm not saying it's not bad, but we have to now convict of voyeurism, sharing, and 2 counts of sexual assault.
One of the things in the
where clearly they consented to the sexual act, it's the recording. So I believe in attacking the thing that you did, which is particularly wrong, and not stretching out, because I'm concerned about what else strikes at the dignity and equality rights of whoever the complainant is. I'm concerned about that as to where we go. I'm concerned because when we talk about, where we're going about being awakened to discrimination and to equality issues and to violence against women, violence against men. I'm concerned that we go too far, that a person is not subject to 1, 2, 3, or 4 charges, but 10, 12, and the sentences are just going to stack up, and we're going to lose sight of what we're trying to accomplish here.
One of the things I think to be made clear with the Rockburn case is that the judge did come to the conclusion that the women consented to the sexual activity.
The fucking witnesses said we consented.
Yeah, so they consented. There was no rape going on. The only thing under discussion was whether or not
That was a difficult analysis.
whether or not the recording of the sexual act without their knowledge completely negated the fact that they were consenting to what was being recorded.
And that's weird logic to understand for most people.
Again, look, there other people will argue to us and say, what are you talking about? I mean, this was intricate to my consent. I mean, let's put ourselves in the position of somebody who'd be recorded in this situation or say, I consented to sex with you in private.
Yeah, well, if you say the word weather or something like that, then your Google phone will predict what you're going to, like, we're all being recorded all the time, so.
Is that, we're done?
Yeah, I think we're done.
I'm so unsatisfied with this result. I want to talk about it more. Here, pick up your glasses.
But we can't because we're going to have to leave it up to the courts to.
Well, I think we should follow this, and
we're going to have to wait for the Supreme Court to decide that they finally feel like weighing in on the issue.
If they feel like it.
If they feel like it.
They're going to have to feel like it on this one. But what was so interesting? I'll just say this one thing, and I thank our viewers because they were like,
who are going to subscribe. Hit notifications and share all the videos.
But we got a lot of really great engagement when it went live. People are asking really interesting questions. We've got people saying hi from, I forgot where, from the UK, from New Zealand, from all sorts of places. And they're asking, great questions about Canadian law and how it's applicable. But because we've been getting such great dialogue and some great questions, that's why I want this to be a larger discussion. We're going to revisit this when we see what the appeals say. And as a society, this may be where we're supposed to go. I, on the other hand, would like to construe these things much more narrowly to avoid abuses and then for over-criminalizing. And I'll just be quiet now. Thank you. Thank you. Good night, everybody.
That's why I love you.
Never be quiet, Joe.